Greetings. I wanted to start out this fine, beautiful morning by getting back into the Sheriff's Handbook. And I was reached out by quite a few people who were asking me, how do you gain and retain all this presumed and assumed knowledge that you have? And I will tell you the key to success is just like anything else. It's repetition. I have studied Patrick Devine, KW, Weiss Handbook on Trust, Lewin on Trust, Gibson, Pomeroy, Joseph's Story, you name it. There's a lot of great people like Malika out there, Justin Nolan, just a collective group, Kurt Pendergrass, David Strait, David Jose. Everybody brings something to the table. And I learned from many of you guys that follow me as well, sharing things in the private comments or commenting on what I post. It would take me a century to name all the people who have been influential in my life. So I want to start out by just thanking everybody for believing in me and giving me the opportunity to share the things that I've learned along my journey and path. And I think that's one of the key essential ways to becoming fluent in all this is actually to go through your trials and your tribulations to ascend of the mind and to know who you are. Obviously, that development only comes with firsthand knowledge and experience. And so I want to thank all you guys first and foremost. Tonight, this morning, we're going to get back into the Sheriff's Handbook. Legislative law is vested law. Neither the U.S. Congress nor the state Congress has the authority to write statutes that control people's behavior. All right, so let's break that down a little bit. Congress was never vested with the power to tell you and I how to live our lives. They were vested with the power to control the government corporation and its subsidiary corporations with policies or law, quote unquote, that apply to them. All right. And the legislator, furthermore, doesn't have the authority to write law that pertains to the average men and women. Just the same, the IRS does not have the authority to create edicts that everybody is bound by, all right? But ignorance of the law excuses no one, and if you choose to volunteer into those programs, well, then you're subjected to them until you rescind your signature, revoke your signature, terminate the contracts, etc., okay? It's up to the people to control their own behavior, and if they injure someone, the common law has remedies. Vested authority in our legislator is found in Article 1, Section 8. Congress absolutely has no authority to legislate outside of Article 1, Section 8. The real law, the common law, is the real law, the supreme law of the land. The codes, rules, regulations, policies, and statutes, quite simply, ladies and gentlemen, are not law. Self versus Ray, RHAY 61 WN 2D 261. Legislated statutes enforced upon the people in the name of law are a fraud. Okay? They have no authority and are without mercy. Justice without mercy is godless and therefore repugnant to our United States Constitution. Lawmakers were given the authority by the people to legislate codes, rules, regulations, and statutes, which are policies, procedures, and law to control the behavior of bureaucrats, all right? Elected and appointed officials, municipalities, and agencies, however, they were never given authority to control the behavior of the people. Remember, the government was instituted amongst men to protect their unalienable rights. That was to the extent that government was created, all right? Not to control people's behavior. As we read in the U.S. Supreme Court decision, all laws, rules, and practices which are repugnant to the Constitution are null and void. Mulberry versus Madison, 5th U.S. 2 Cranch, 137, 174, 176. This case happened in 1803. Legislators simply do not have the authority to rule make. Where rights secured by the constitutions are involved, there can be no rule-making or legislation which would abrogate them. Miranda versus Arizona. Now, I will be honest. when I first really read the case about Miranda versus Arizona, I was kind of appalled because it seemed as though the Miranda that was being called into question was being pretty nefarious and may have been involved in exploiting children. All right. So my heart was kind of torn in half reading that case because I was like, how could something so good come from something so sinister? Now, many people quote Miranda versus Arizona, but I can tell very few have ever actually read it because the case is quite heinous. But the procedures and methods that were utilized in order to ascertain the evidence ultimately ruled that evidence as null and void because it was collected and had illegally by violating Miranda's rights. Okay, so Miranda versus Arizona, you should go read it, become familiar with it. I'm sure you'll have the same disdain as I have for that case, understanding what was articulated in it. But nevertheless, we did get something good out of Miranda versus Arizona. We got a firm, established fact that you have to have your rights read to you, and you have to agree to things before you're interrogated. Okay, it's a contract. 384 U.S. 436 491. God breaks down the laws as follows, and Jesus answered him, the first of all the commandments is here, O Israel, the Lord of our God is one Lord, and thou shalt love the Lord thy God with all thy heart, and with all thy soul, and with all thy mind, and with all thy strength. This is the first commandment. And the second is like namely this, thou shalt love thy neighbor as thyself. There is none other commandment greater than these. Mark 12:29 through 31. Although it is a sin punishable only by a judge of the universe to break the commandments to love in your mind, words, and deeds, it does not become a crime. Now, I had a conversation the other day with a pretty enlightened man talking about crimes. He says, Derek, what you're talking about is a criminal it's a unlawful trespass. It's a tort in the common law. A crime actually is only supported in the public sector, and that's a breach of policy becomes a crime. Murder is unlawful, versus murder in the second degree, which is illegal, okay, or some other policy that has been violated would be the crime. But murder is unlawful, and let's just say, for the sake of argument, Grand Theft Auto. Grand Theft Auto is a policy violation. It is a crime. Whereas theft would be a tort action at the common law. Theft is unlawful. It's also illegal. However, when they define these terms in their codes, regulations, it applies to the public sector, okay? The volunteers and the employees of the government. Punishable by man until your words and deeds are expressed in actions injuring another. Thomas Jefferson said, I would rather be exposed to the inconveniences attending too much liberty than those attending too small a degree of it. If one of the people exercises his free will to carry a weapon, travel, practice law, park without depositing money in a meter, use hemp, pharmaceuticals, alcohol, vitamins, minerals, or any other substance for medicinal or recreational purposes, the legislator do not have the authority to impose a fine, license, or make a right a crime. Sheriff and statutes. An important point that all judicial officers should know is that lawful statutes are written to govern elected, appointed, and hired government servants. The United States Constitution, Article 1, Section 8, empowers Congress with the following power to write laws. 1. To tax and pay debts and provide for the common defense and general welfare of the United States. 2. To borrow money. 3. To make regular commerce with foreign nations and the states. 4. To establish a uniform rule of naturalization and bankruptcy laws. 5. To coin money and fix the standards of weights and measures. 6. To provide for the punishment of counterfeiting. 7. To establish post office and post roads. 8. To promote the progress of science and useful arts. 9. To constitute district courts inferior to the Supreme Court. 10. To define and punish piracy. 11. To declare war. 12. To raise and support armies. 13. To provide and maintain a navy. 14. To make rules for land and naval forces. 15. To provide for calling forth the militia. 16. To provide for organizing, arming, and disciplining the militia. 17. To exercise exclusive legislation in Washington, D.C. and forts, magazines, arsenals, dockyards, and other needful buildings. 18. To make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution. Take note, Congress was never given the power to write statutes to control the behavior of we the people, nor can they without violating our unalienable rights. Therefore, that power to control our own behavior belongs to each one of us, and we are responsible for our own actions to do no harm. This is the great American experiment. The following codes, aka statutes, are examples of legislation that protect the people's unalienable rights and impose fines and prison sentences upon elected and appointed servants who abuse their power under the color of law. The jury has the power and authority to change fines into restitution, and they should, because currently the fines are simply used to enrich the state. They also have the power and authority to make the restitution or punishment greater or lesser. If the convicted is placed on probation or house arrest, they may and should be required to pay for said services. Title 18 USC Subsection 241, Conspiracy Against Rights. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any rights or privileges secured to them by the Constitution or laws of the United States, or because of his having so exercised the same, or if two or more persons go in disguise, police officers acting under the color of law, on the highway or on the premises of another, with the intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured, they shall be fined under this title or imprisoned not more than 10 years, or both. And if death results from the acts committed in violation of this section, or if such acts includes kidnapping or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, they shall be fined under this title or imprisoned for any term of years, or for life, or both, or may be sentenced to death. Title 18 USC Subsection 242, Deprivation of Rights under color of law. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such person being an alien or by reason of his color, ethnicity, or race, than are prescribed for the punishment of citizens shall be fined under this title or imprisoned not more than 1 year, or both. And if bodily injury results from the acts committed in violation of this section, or if such acts include the use, attempted use, or threatened use of dangerous weapons, explosives, or fire, shall be fined under this title or imprisoned not more than 10 years, or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping or attempted kidnap, or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, shall be fined under this title or imprisoned for any term of years, or for life, or both, or may be sentenced to death. Let me blow my nose real quick. All right. Color of law. The appearance or semblance without the substance of legal right. State versus Bretschler, 185 Wisconsin, 599, 202, N period, W period, 144, 148. Misuse of power possessed by virtue of state law and made possible only because wrongdoer is clothed with authority of state. Is action taken under color of state law. Atkins versus Lanning, 415 F period, Superior Court period, 186, 188. Title 18 USC subsection 645. Court officers generally, whoever, being a United States Marshal, clerk, receiver, referee, trustee, or other officer of a United States court, or any deputy, assistant, or employee of any such officer, retains or converts to his own use or to the use of another, or after demand by the party entitled thereto, unlawfully retains any money coming into his hands by virtue of his official relation, position, or employment, is guilty of embezzlement, and shall, where the offense is not otherwise punishable by enactment of Congress, be fined under this title, or not more than double the value of the money so embezzled, whichever is greater, or imprisoned not more than 10 years, or both. But if the amount embezzled does not exceed $1,000, and it just says 1,000, he shall be fined under this title or imprisoned not more than 1 year, or both. It shall not be a defense that the accused person had any interest in such monies or funds. Title 18 USC subsection 654, officer or employee of the United States converting property of another. Whoever, being an officer or employee of the United States or of any department or agency thereof, embezzles or wrongfully converts to his own use the money or property of another which comes into his possession or under his control in the execution of such office or employment, or under color or claim of authority as such officer or employee, shall be fined under this title, or not more than the value of the money and property thus embezzled or converted, whichever is greater, or imprisoned not more than 10 years, or both. But if the sum embezzled is $1,000 or less, he shall be fined under this title, or imprisoned not more than 1 year, or both. Title 18 USC subsection 872, extortion by officers or employees of the United States. This is so important. Whoever, being an officer or employee of the United States or any department or agency thereof, or representing himself to be or assuming to act as such under color or pretense of office or employment, commits or attempts an act of extortion, shall be fined under this title, or imprisoned not more than 3 years, or both. But if the amount so extorted or demanded does not exceed 1,000, he shall be fined under this title, or imprisoned not more than 1 year, or both. Title 18 USC subsection 1001. This is one of my favorites. Statements or entries generally. A. Except as otherwise provided in this section, whoever in any matter within the jurisdiction of the executive, legislative, or judicial branch of government of the United States knowingly and willfully, 1. Falsifies, conceals, or covers up by any trick, scheme, or device a material fact. 2. Makes any materially false, fictitious, or fraudulent statement or representation. Or 3. Makes or uses any false writing or documents knowing the same to contain any false, materially false, fictitious, or fraudulent statement or entry, shall be fined under this title, imprisoned not more than 5 years, or if the offense involves international or domestic terrorism as defined in section 2331, imprisoned not more than 8 years, or both. If the matter relates to an offense under chapter 109A, 109B, 110, or 117, or sections 1591, then the term of imprisonment imposed under this section shall not be more than 8 years. Title 18 USC subsection 1503, influencing or injuring officers or juror generally. A, whoever corruptly or by threat or force or by any threatening letter or communication endeavors to influence, intimidate, or impede any grand jury or petit jury or officer in or of any court of the United States, or officer who may be serving at any examination or other proceeding before any United States magistrate judge or other committing magistrate in the discharge of his duty or injures any such grand or petit juror in his person or property on account of any verdict or indictment assented to by him or on account of his being or having been such juror, or injures any such officer, magistrate, judge, or other committing magistrate in his person or property on account of the performance of his official duties, or corruptly or by threat of force or by any threatening letter or communication influences, obstructs, or impedes, or endeavors to influence, obstruct, or impede the due administration of justice, shall be punished as provided in subsection B, if the offense under this section occurs in connection with a trial of a criminal case, and the act in violation of this section involves the threat of physical force or physical force. The maximum term of imprisonment which may be imposed for the offense shall be the higher of that otherwise provided by law, or the maximum term that could have been imposed for any offense charged in such case. Title 18 USC Subsection 1512B engages in misleading conduct. B, whoever knowingly uses intimidation, threats, or corruptly persuades another person or attempts to do so, or engages in misleading conduct towards another person with the intent to, 1, influence, delay, or prevent the testimony of any person in an official proceeding, 2, cause or induce any person to, A, withhold testimony or withhold a record, document, or other object from an official proceeding, B, alter, destroy, mutilate, or conceal an object with intent to impair the object's integrity or availability for use in an official proceeding, C, evade legal process, summoning that person to appear as a witness or to produce a record, document, or other object in an official proceeding, or D, be absent from an official proceeding to which such person has been summoned by legal process, or 3, hinder, delay, or prevent the communication to a law enforcement officer or judge of the United States of information relating to the commission or possible commission of a federal offense or a violation of conditions of probation. 1, supervised release, parole, or release pending judicial proceedings shall be fined under this title or imprisoned not more than 20 years, or both. Title 18 USC Subsection 2071, concealment, removal, or mutilation generally. A, whoever willfully and unlawfully conceals, removes, mutilates, obliterates, or destroys, or attempts to do so, or with intent to do so, takes and carries away any record, proceeding, map, book, paper, document, or other thing filed or deposited with any clerk or officer of any court of the United States or in any public office, or with any judicial or public officer of the United States, shall be fined under this title or imprisoned not more than 3 years, or both. B, whoever having the custody of any such records, this is very important, any such records, proceedings, map, book, documents, paper, or other things, willfully and unlawfully conceals, removes, mutilates, obliterates, falsifies, or destroys the same, shall be fined under this title or imprisoned not more than 3 years, or both, and shall forfeit his office and be disqualified from holding any office under the United States as used in this subsection. The term office does not include the office held by any person as a retired officer of the armed forces of the United States. Title 18 USC Subsection 2076. For you guys listening, write these down. They're super important. Whoever, being a clerk of a district court of the United States, willfully refuses or neglects to make or forward any report, certificate, statement, or document as required by law shall be fined under this title or imprisoned not more than 1 year or both. For those of you having problems with the clerk of the court saying, I'm not going to accept this document, it's not in the proper format, we're not going to accept it, they're violating Title 18 USC Subsection 2076 of this title. Clerk is to file, period. She's not allowed to make legal determinations, and the reason I say she is because most often clerks of the court are women. I have my reservations as why that is. They pay more acute attention to detail. It's just my thought process. I could be horribly misguided in that thinking. It's misogynist, I guess, in such a way. But anyway, moving forward. Title 26 USC Subsection 7214. Title 26 deals with the IRS, the IRC, the tax code, right? Offenses by officers and employees of the United States. A. Unlawful acts of revenue officers or agents. Any officer or employee of the United States acting in connection with any revenue law of the United States. 1. Who is guilty of any extortion or willful oppression under color of law. Or 2. Knowingly demands other or greater sums than are authorized by law or receives any fee, compensation, or reward except as by law prescribed for the performance of any duty, shall be dismissed from office or discharged from employment, and upon conviction thereof shall be fined not more than $10,000 or imprisoned not more than 5 years or both. The court may in its discretion award out of the fine so imposed an amount not in excess of 1/2 thereof for the use of the informer, if any, who shall be ascertained by the judgment of the court also shall render judgment against the said officer or employee for the amount of damages sustained in favor of the party injured to be collected by execution. Title 42 USC Subsection 1983. Civil actions for deprivation of rights. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory of the District of Columbia, subject or cause to be subjected any citizen of the United States or other person within their jurisdiction thereof to the deprivation of any rights, privileges, or immunities. Now, here's the thing. Privileges and immunities here. You have a foreign sovereign immunity status if you know what you're doing, okay? When they're talking about privileges and immunities in the civil law, they're talking about you being a volunteer subject, all right, which the Constitution does not apply to you. And I've done a tremendous amount of research on this, and I can't find any lawyer, any judge, any politician that wants to deny these facts, all right? So you have rights, but in the political sphere of things, they're called civil rights, and civil rights are not unalienable rights. So please do not misconstrue the difference between civil rights and unalienable rights. They're two different jurisdictions in two separate, very separate venues, okay? So, secured by the Constitution and law, shall be liable to the party injured in an action at law, suits in equity, or other proper proceedings for redress, except that in any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. For the purpose of this section, any act of Congress applicable exclusively to the District of Columbia shall be considered to be a statute of the District of Columbia. All right? Title 42, USC, subsection 1985. This is not something many people talk about. 3, conspiracy to interfere with civil rights. Depriving persons of rights or privileges. If 2 or more persons in any state or territory conspire, okay, now we're talking about states and territories. Territories is referring to the District of Columbia the Samoan Islands, the Outer Minor Line Islands, the District of Columbia. It's not talking about the Union of States, all right? Conspire or go in disguise on the highways or on the premise of another for the purpose of depriving either directly or indirectly any person or class of person. And you notice how they put class of person there? All right. United States citizen is a different type of class of person. All right. It is not a member of the Union of States, of the equal protection of the laws, or equal privileges and immunities under the law, or for the purpose of preventing or hindering the constituted authorities of any state or territory from giving or securing to all persons within such state or territory the equal protection of the laws, or if two or more persons conspire to prevent by force, intimidation, or threat any citizen who is lawfully entitled to vote. Okay, let me just clarify some jurisdictional issues here. Voting is all part of Washington, D.C., District of fucking Criminals. Electors are part of the Union of State members, okay? Union of State people are the state nationals, the Union State members, are protected by not only the state constitution, but also the federal constitution, okay? Whereas voters are not necessarily. They're subject to all this hoobly-gock because they're volunteers or they're employees being fucking paid, okay? So you have to make a conscious decision with this information what side of the fence you want to stand on. And being a fucking fence rider will not work in your favor, because he who contradicts himself shall not be heard. And then they cast you to the wayside as somebody who's mentis incompetent. You're not of sound mind. You don't know what you're doing. You need to be taken care of. You're a ward of the state. You're a ward of the court. They're going to take care of you, all right? From giving his support or advocacy in legal manner toward or in favor of the election of any lawfully qualified person as an elector for president or vice president, or as a member of Congress of the United States, or to injure any citizen in person or property on account of such support or advocacy. In any case of conspiracy set forth in this section, if one or more persons engages therein do or cause to be done any act in furtherance of the object of such conspiracy whereby another is injured in his person or property, or deprived of having and exercising any right or privilege of a citizen of the United States. What is a citizen of the United States, ladies and gentlemen? A citizen of the United States is a slave, a serf, a pauper, okay? You're either a state national and you owe an allegiance to your state, or stop swimming and dry out. I have no idea what you're talking about, buddy. Privileges of a citizen of the United States. The party so injured or deprived may have an action for the recovery of damages occasioned by such injury or deprivation against any one or more of the conspirators. Title 42 USC Subsection 1986, Actions for Neglect to Prevent. Every person who, having knowledge that any of the wrongs conspired to be done and mentioned in Section 1985 of this title are about to be committed, and having power to prevent or aid in the preventing the commission of the same, neglects or refuses so to do, if such wrongful act be committed, shall be liable to the party injured or his legal representatives for all damages caused by such wrongful act, which such person by reasonable diligence could have prevented, and such damages may be recovered in an action on the case, and any number of persons guilty of such wrongful neglect or refusal may be joined as defendants in the action. And if the death of a party be caused by any such wrongful act and neglect, the legal representatives of the deceased shall have such actions therefore, and may recover not exceeding 5,000 damages therein, for the benefit of the widow of the deceased. if there be one, and if there be no widow, then for the benefit of the next of kin of the deceased. But no action under the provision of this section shall be sustained, which is not commenced within 1 year after the cause of action has occurred. Oath. Any form of attestation by which a person signifies that he is bound in conscience to perform an act faithfully and truthfully. Vaughn versus State, 146, Texas, CR period R period 586 177 S period W period 2D 5960. A solemn appeal to the Supreme Being is attestation of the truth of some statement. State versus Jones, 28, Idaho, 428, 154, page 378 through 381. Tyler's Oath, 15. An external pledge or asseveration made in verification of statements made or to be made, coupled with an appeal to a sacred or venerated object in evidence of the serious and reverent state of mind of the party, or with an invocation to a supreme being to witness the words of the party and to visit him with punishment if they be false. June versus School District Number 11, Southfield TP 283, Michigan, 533, 278, N period W period 676, 677, 116, A period L period R period 581. Political, pertaining to the exercise of the function vested in those charged with the conduct of government relating to the management of affairs of state, as political theories of or pertaining to the exercise of rights and privileges or the influence by which individuals of a state seek to determine or control its public policies, having to do with organizations or actions of individuals, parties, or interests that seek to control appointment or action of those who manage affairs of a state. State ex rel. Malley versus Civic Action Committee, 238, Iowa, 851-28, N period W period 2D 467-470. Politics, the science of government, the art or practice of administrating public affairs. Comment, unfortunately, empty campaign promises along with exaggeration and lies launched against one's political opponent seems to have robbed the said term of its true meaning, and when compounded by the so-called news media, has made it impossible for the general public to discern the truth. This is why our government is occupied by mostly sleazy, lawless servants who act as our masters and abuse the people, not unlike the King of Great Britain in 1776. Rights and sovereignty. Sovereign is defined in Black's law as a person, body, jury, or state in which independent and supreme authority is vested, a chief ruler with supreme power, a king or other ruler with limited power, whereas sovereign authority was vested in we the people through unalienable rights by nature's God, and sovereign authority was vested in the state through the Constitution by we the people. Only people are sovereign, subject unto God alone, and have rights vested by God. Romans 13, 1 and 2. Let every soul be subject unto the higher power, for there is no power but of God. The powers that be are ordained of God. Whosoever therefore resisteth the power resisteth the ordinance of God, and they that resist shall receive to themselves damnation. Sovereignty is superlative, and thus admits to no degrees of sovereignty by definition. Sovereignty resides only in that one God, deriving no authority from another. Romans 13, 1 and 2. In earth, men are ordained sovereigns and subject only to God. Bureaucrats, in their capacity, are not sovereign and have no rights. They have authority given by the people, subject to the Constitution, and have a duty to speak when demanded by the people to give an account. The state cannot diminish rights of the people. Hurtado, Hurtado, versus People of the State of California, 110 U.S. 516. The assertion of federal rights, Bill of Rights, when plainly and reasonably made, is not to be defeated under the name of local practice. Davis versus Weschler, 263 U.S. 2224. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda versus Arizona, 384 U.S. 436 491. There can be no sanctions or penalty imposed upon one because of this exercise of constitutional rights. They're not constitutional rights, they're unalienable rights, they're constitutionally protected. Sharir versus Cullen, 481 F 946. Sovereignty itself is, of course, not subject to the law, for it is the author and source of the law. Yikwu versus Hopkins, 118 U.S. 356 370. Undersigned in sovereign, and no court has challenged that status or standing. Thus, man being no source or spring of law is no sovereign. Therefore, God is sovereign, and man is vested by God to self-govern, and thereby the author of the Constitution, the law of the land by which all government servants are bound. This is what makes the United States of America different than any other nation. If we lose these truths, we lose our liberty. Licensing liberty. No state shall convert a liberty into a license and charge a fee therefor. Murdoch versus Pennsylvania, 319 U.S. 105. If the state converts a right, liberty, into a privilege, the citizen can ignore the license and fee and engage in the right, liberty, with impunity. Shuttlesworth versus City of Birmingham, Alabama, 373 U.S. 262. Remedy for every injury. William Blackstone, a legal maximum, every right, when withheld, must have a remedy, and every injury its proper redress. In the third volume of this commentaries, page 23, Blackstone states 2 cases in which a remedy is afforded by mere operation of law. In all other cases, he says, it is a general and an indisputable rule that where there is a legal right, there is also a legal remedy by suit or action at law whenever the right is invaded. And afterwards, page 109 of the same volume, he says, I am next to consider such injuries as are cognizable by the courts of common law. And herein I shall for the present only remark that all possible injuries whatsoever that did not fall within the exclusive cognizance of either the ecclesiastical, military, or maritime tribunals are, for that very reason, within the cognizance of the common law courts of justice, for it is a settled and invariable principle in the law of England that every right, when withheld, must have a remedy, and every injury its proper redress. 5 U.S. 137, Mulberry versus Madison. The government of the United States has been emphatically termed a government of laws and not of men. It will certainly cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right. Mulberry versus Madison, 5 U.S. 137. The case was held in 1803 and has never been overturned. Okay? And it's been used thousands of times, maybe even hundreds of thousands of times in court, and it has never been overturned. It's so important to realize that. That statutes which would deprive a citizen of the rights of persons or property without the regular trial according to the course and usage of the common law would not be the law of the land. Hoke versus Henderson, 15 in period C period 15, 25 AMDEC 677. The right to be let alone, the most comprehensive of rights and the right most valued by civilized men. To protect that right, every unjustifiable intrusion by the government upon the privacy of the individual, whatever that the means employed, must be deemed a violation of the Fourth Amendment. Olmstead versus U.S. 277, U.S. 438, 478, 1928. Now, something to think about here is Edward Snowden talking about the NSA and the government spying on every American unconstitutionally, not with any warrant, although under the guise, in good faith, done for great reasons to protect from domestic terrorism and terrorism afoot and abroad in other countries. Although it sounds real nice, they're really chiseling away at your right of privacy. And many people in the 21st century don't even understand how valuable privacy really is. Congress cannot alter rights. On the other hand, it is clear that Congress cannot by authorization or ratification give the slightest effect to a state law or constitution which is in conflict with the Constitution of the United States. 16 Am Jurisprudence 2D, Section 258. Rights do not come in degrees. Although it is manifested that an unconstitutional provision in the statute is not cured because included in the same act with valid provisions, and that there is no degree of constitutionality. 16 Am Jurisprudence 2D, Section 260. States cannot license rights. A state may not impose a charge for the enjoyment of a right granted by the federal Constitution, and that a flat license tax here involves restraints in advance the constitutional liberties of press and religion, and inevitably tends to suppress their exercise. That the ordinance is non-discriminatory, and that it applies also to peddlers of wares and merchandise is immaterial. The liberties granted by the First Amendment are and in a preferred position, since the privilege in question is guaranteed by the federal Constitution and exists independently of the state's authority. The inquiry as to whether the state has given something for which it cannot ask a return is irrelevant. No state may convert any secured liberty into a privilege and issue a license and a fee for it. Mudook, M-U-D-O-O-K versus Penn, 319 U.S. 105. This case happened in 1943. If the state does convert your right into a privilege and issue a license and a fee for it, you can ignore the license and the fee and engage the right with impunity. Shuttlesworth versus Birmingham, Alabama, 373 U.S. 262. This case was affirmed in 1962 and has never been overturned. Interpretations in favor of we the people. Any constitutional provision intended to confer a benefit should be liberally construed in favor of the clearly intended and expressly designated beneficiary, which would be we the people. Then a constitution should receive a literal interpretation in favor of the citizen. Is especially true with respect to those provisions which were designed to safeguard the liberty and security of the citizen in regard to persons and property. Shall not interfere. Various facts or circumstances intrinsic to the Constitution are often restored to by the courts. Various facts of circumstances extrinsic to the Constitution are often resorted to by the courts to aid them in determining its meaning. As previously noted, however, such extrinsic aids may not be restored to where the provision in the question is clear and unambiguous. In such a case, the courts must apply the terms of the Constitution as written, and they are not at liberty to search for meanings beyond the instrument. 16 Am Jurisprudence 2D, Section 117. We're going to get to the preamble when we come back, and I have some other information here that I'll be sharing with you guys as well from false arrests and imprisonments, and it's a treatise on false arrest and imprisonments, which is bust down the most basic fundamental rights about false incarcerations, false arrest, and things of that nature. So when we come back, thanks for joining me again. When we come back, we'll hit up the preamble and the Bill of Rights.